and I'm an attorney with Codd Sangster. I specialize in commercial real estate as well as commercial litigation, title disputes and title marketability, and just in general, real estate is an area where I feel comfortable and strongly about. It's something I've been doing for a long time and before I was a lawyer. So I understand the practical application of it and also from a perspective of a lawyer. So without further ado, let's get going. All right, so the first part of this presentation and the largest part of it is going to be case law study based upon some recent opinions and rulings by various courts across the state of Michigan. I try to keep most of them in 2020, 2021, to make sure they're relevant and they assist you in understanding this unique area of real estate titles and real estate marketability. So the first case is actually Matthew E. Granda v. George Hawkins. It's an unpublished opinion. The Court of Appeals issued on October 15, 2020. And this presentation will be circulated among everyone, so you guys will have the details, the cases that are cited in case you want to refer back to them. You're obviously always welcome to reach out to me if you have any further questions. This one is an interesting, well, I find it interesting. Interesting case where the original owner owned some a massive amount of land and parcels, and eventually decided, we're going to let go of this parcel. These are primarily just woods, wetlands, with really no development on them. So, it's hard to develop thousands and thousands of acres of land, so instead you sell it. So the original owner divided this among various smaller parcels. And when I say smaller, I mean relatively speaking. They ended up being somewhere between 160 to 320 acres. So they were divided, they were sold off. And then as you can see, they were used for hunting and recreational land parcels. And that could be anything from, family activities or even any commercial activities that you can think of in, whether it's fishing or hunting, whatever it may be. So the plaintiff in this case, who we mentioned earlier, was Matthew E. Granda, purchased one of the properties was mainly hunting land, and it was the only way to access the property was actually through federal land. So they had an easement and were a right to get access to their property, and they had to go through miles and miles of, not miles and miles, a couple of miles of federal land to get access to their property. And it was a federally controlled forest. So you can just imagine it was a dirt road, they would access it. The federal government had granted them a permit for the longest time, and that's how they accessed it. But unfortunately, due to people leaving a lot of dirt behind, a lot of garbage behind, and some other crimes that occurred in this forest, the federal government decided that they no longer want an easement or a permit that allows, public unfettered access through this area, which is allegedly was damaging the area and causing harm to the environment. So eventually the federal government nicely put it to the owner and said, look, your permit is expiring. We're not going to renew it, but we recommend that you pursue access through the east, which is a property owned by another private owner, not a government entity, but a private owner. And that's, there's a reason why I emphasize that. So they recommend they go talk to this private owner, work something out, and gain access to their property. Now, this private owner's property actually had access to the primary road, the highway that led up to this area. I think it was, if I remember correctly, I think it was US 23, if I'm correct in my recollection. Regardless, that was a primary street that grants access to anyone who wants to get to this area where all these large parcels are. So the owner, the plaintiff, Matthew, said, look, you know what? I'm going to go talk to Mr. George Hawkins. I'm sure he's a reasonable man, and we'll work something out. Well, as you can see, eventually plaintiff had to file an action seeking an easement by necessity, which means that they were unable to work anything out. And the easement by necessity is essentially what it sounds like. The legal basis behind it is that this property, without access to it, will have no value at all. So based upon the current circumstances, for whatever reason they arose, which we'll get into later, we should be allowed access to the property, to our property, so we can actually have actually use our property and enjoy our property. This, and keep in mind, this option, it occurs a lot more in rural properties, but it can also occur in more urban settings as well, as more and more development is happening. And at times people, because of development, they lose access to their property from the original easement, and they may require another easement to grant access to their property. So it can happen even in a place like City of Detroit, especially when you have so many different parcels that change owners, and the legal descriptions are not as clear, and easements are not as clear. So turns out the defendant, they were trying to be reasonable here. They weren't being completely unreasonable. The details are not in there as to, whether there's any pleasantries exchanged, or, if anyone was upset or didn't like each other. But the defendant basically said, look, it seems reasonable. I don't want disruption through my property. They actually used it for private use, for their family to come out there for hunting and skiing, a bunch of other activities. And let me see here, actually, there's a lot of details to it. Give me one sec. Okay. Yeah, I had a bunch of details in there regarding what they were using it for, but essentially they were using it for a lot of family access, like hunting. They were doing a lot of dinners out there. They were inviting people for skiing, and a bunch of other sports and activities. So they wanted that privacy. When you have a bunch of people accessing your property through the middle of the property through an easement, that disrupts that. So the rationale behind this objection was that, look, they don't want to be disruptive, but they're still being reasonable. We don't want you to gain access to the middle of our property, but you can gain access to the northern area or to the southern area. So you go around it and you can get to, the main road. Plaintiff obviously wanted through the center. So what the lower court ruled was that the easement was granted. The plaintiff got the easement, but the court ruled that you will only have access to either the northern or the southern part, and not to the center. Plaintiff, even though they got the easement, was upset and appealed. One of the reasons they appealed, they said, look, the MDEQ, Michigan Department of, what is MDEQ? Michigan Department of, I want to say agriculture, but economic, man, now I forgot what MDEQ stands for. There, I'll double check. Yeah, Environmental, Great Lakes, and Energy, which is now EGLE, actually. That's why I forgot, because it's known as EGLE now. So they did not have access through the center line. And they said, look, we can't go to the northern or southern lands because there's wetlands there, and MDEQ won't allow us to build a road there. Court of Appeals eventually, and then I'll give you the conclusion first, affirmed the decision based upon equitable considerations for the owner of the servient estate. So servient estate means the burdened property. The property here, which is the defendant owns, meaning they're burdened by the plaintiff's access. And the equitable considerations were, look, every person has a right to enjoy their property. And have access to the property, and the courts are in favor of granting people access to their property, but they also don't want to impose or go beyond the absolute minimum intrusive way of granting access through someone else's private property. And the various items that looked at here were, one, what would be the cost to a plaintiff to build to the center versus from the north or to the south. And the cost here, we're talking about $200,000, $240,000. These are the type of quotes that were being shared by the plaintiff in trying to establish that, look, it'll cost us too much to go around versus the center. Defendant had their own experts who testified that, look, no, it actually may cost just as much as going through the center as a side. And also, there's the issue of not only money, but the equitable consideration that we won't be able to enjoy our property. This is not the least intrusive way of granting access. The court eventually agreed with the defendants, stating, look, the idea that the plaintiff cannot build to the north or south side, they haven't established that with enough evidence. There was evidence in there that MDEQ won't object to plaintiff building. The main issue was plaintiff, it was going to be a longer route and perhaps slightly more expensive. Plaintiff obviously wanted the center route for various reasons, but didn't get that. Again, it was really to protect the defendant here, who was giving up the right and saying, look, we will give you access, but we just don't want you to go through the middle of our property where my family will be enjoying hunting. Imagine them hunting and there's a bunch of random cars going through the middle that they're not aware of. They're supposed to be there and they're out there hunting, and that can result in a lot of accidents and issues. So court looked at all these considerations and weighing the factors in favor of the defendant here to making sure their privacy rights and their rights were protected. And eventually affirmed the decision and said, look, the lower court got it right. I'm about to jump to the next slide now, the next case. If you guys have any questions, feel free to ask those. I don't see anything popping up right now, so I'll keep talking until I see something. Okay, this next case law study deals with title insurance coverage, the ability to obtain coverage. It's an interesting case. That's actually kind of what actually occurred and resulted in the dispute here was interesting and funny. The case is called, again for reference, as Peter Horwood, Horwood, and Irina Horwood v. North American Title Insurance Company. The plaintiff in this case, the Horwoods, they acquired title to the property in Green Oak Township, and they got a title insurance policy from the defendant. Plaintiff's property actually bordered the property owned by their neighbors, and they also had, in the legal description of their property, they had an easement to gain access to their property, plaintiff's property. Again, an easement, trying to gain access to their property. Similar circumstances, but a little bit different issue here. So you'll notice that the case is not against the defendants here. The case is plaintiff against their title insurance company seeking coverage. And we'll get into how we got there. I just want to set up the background to make sure you guys understand what led to the eventual dispute. There was, as you can see, the Roses claimed that plaintiffs did not have an easement. So the Roses are the defendants. They were alleging that, look, the plaintiff does not have an easement. I don't know what made them believe that. Perhaps their legal description, or maybe the documents that were in that they had regarding historical records did not show a easement, or the opinion is not clear as to why they had this belief. But you'll notice later on in this presentation, we'll discuss how that can come about, where if one person may have a different legal description and rights to their property versus another owner that may not have found the same thing in their legal search, in the title search. That can happen frequently. For whatever reason here, which is unknown to us, the Roses, the neighbors, believe there was no easement here. looks like the plaintiff was also not playing nice. I don't know who started it, but plaintiff the neighbors filed a lawsuit alleging that the plaintiff trespassed on their property, spun the tires of a pickup truck while holding a middle finger up, caused damage to the Rose's septic field and trees, removed portion of the Rose's fence, planted vegetation, and placed cameras on the property line facing the Rose's house. That's pretty, everything else is obviously crazy, but then also going as far as placing cameras, not on a property that you own, an alleged easement. So the easement is not something that's legally your property that you have title to. For example, if I have easement to cross the street to get to, if the utility company has an easement through my property to get into my property to fix something, that easement is limited to that portion. They don't have a title to my property. So easement never gives you title. So here, you have an easement to access your property. You don't have the easement to install cameras on your neighbor's property. So for whatever reason, even if they did truly have an easement, they were in the wrong by doing so. So the Roses, they filed an 8-count complaint against the plaintiff. They're obviously upset. Quiet title, that was count 1, that's important to note because a quiet title claim is essentially the crux of this dispute. Quiet title is filed when one person claims that, look, I want the court to rule that I have the sole interest in this property and no one else has interest and I have superior title to this property. In this case, it specifically refers to their easement, saying, look, we have clear title here, there's no easement granted, so I want you to quiet title, right? The trespass, that's in bold. I'll explain later why that's been in bold, because that's part of the dispute with the title insurance company. Malicious destruction of property. Yeah, perhaps there was some of that based on the trucks and the Roses and the septic fields and trees. Conversion, that's a little bit tougher. That's kind of taking someone's property and then not returning it against their will, to put it in layman's term. And I don't see the facts here supporting that. Negligence, maybe invasion of privacy, possibly if there's no easement. Intentional infliction of emotional distress, that's always a tough one, especially with the facts that we know. It's like just, if someone gives you middle finger once, that's tough. But, you could argue that the cameras was kind of excessive. And from then you're always worried about, these people spying on you. So I can see some reasonable argument for that. And the last one's also important and it's relevant here is the injunctive relief. The injunctive relief is the neighbors was court to grant them a equitable, it's an equitable claim for the court to grant them the right to kick plaintiff off in this case. And again, the plaintiffs in this case were the Horwoods. So the plaintiff sought indemnification from the title company on all accounts. So right as the suit happened, the title companies note this, write this down. Your title insurance coverage covers you when your title or perhaps access to your property or any easement that you thought was legally provided to you is no longer available to you for whatever reason. And under standard coverage, you can get endorsements, but under standard coverage, it applies to what happened historically, right? So prior to or up to the point of you buying your property. And that's what the title company will cover is historically and prior to the point of you buying your property, any facts that cause you to lose interest or title in your property. So here the plaintiff filed a complaint or a request of indemnity from the title company saying, look, based upon the legal description you provided to us, which again was provided to us prior to us purchasing this property and closing on the property, and based upon the records that existed, we were supposed to have this easement. Now we're being told that we're going to get kicked off this easement. We won't have access to the property, so you need to indemnify us. Well, the title company did actually agree to defend them for count 1 and count 8, which is why I initially pointed out that quiet title and injunctive relief are important, because those were the two main counts that really pertain to kicking plaintiff off the neighbor's property. So neighbors wanted to kick him off, saying quiet title, meaning these guys cannot have this easement or any injunctive relief to prevent them entering an order stating that these people should never access plaintiff's property, the neighbor's property ever again. So those really pertain to access to plaintiff's property. So the title company had to defend them there because they obviously, the title company covered the easement that was referenced in the legal description that was provided to the plaintiff here. So that kind of sets up the background. I know I kind of jumped around there a little bit, but it gives you the idea that, look, there's a dispute between plaintiff and defendant, and then also the Horwoods are seeking indemnity from the title company. Now, it's a lot easier to get coverage when you're being sued. So the neighbor sued Horwoods seek coverage from their title company because they're being sued, and they want to protect their interest in their property that the title insurance covered against. It is possible to get coverage even in times sometimes when you are the plaintiff and maybe you're filing a lawsuit to gain access to your property or whatever it may be, to clear title, whatever it may be. There are circumstances in which insurance company will cover that. It's more rare. It's not as common as covering defendants, but it does happen. So a lot of insurance policies in general will include a language in there that says that it's our job to defend you. We'll cover the legal fees, but you must also comply with us in reaching a resolution and accepting, a proposed settlement and be reasonable. So here, the settlement that the title insurance company was able to get from the Roses were that the plaintiffs here, the Horwoods, will be allowed access to the easement, but the easement size was reduced. So they, said whatever this dirt road was, whatever it may be, they reduced the size of that and said, look, you'll still have access. Title insurance company said, we got you the results you guys needed. They were preventing you from getting access to your property. Now we have reached a settlement where you can have access to your property, although reduced. It really doesn't change the fact that you have access to your property. Now, there weren't enough details there to show whether the reduction was so substantial that perhaps they can't get their property or car in and out. From what I understood in reading the opinion, it seems like it was still a decent amount of land in a space that they can easily access their property. I use the word forced to accept the settlement because apparently the personal attorney for the Horwoods told them to not take the settlement from a title company of this reduced, not sign off on this reduced easement. But against the advice of their attorney, they did sign off on it, and eventually settled the case with the Roses. Now, the case with the Roses is settled. That's behind us now. Now the focus shifts to the dispute between the plaintiff and the title company about, whether there should have been coverage under count 2 and count 7, and also whether whether there is some sort of compensation that the plaintiff were entitled to because of the reduced size of their easement. So plaintiff obviously were looking for some money, saying, look, we lost some property. We didn't get as much property as you originally promised us in our legal description. And therefore, under our title policy, we are entitled to compensation for that. And they are right, generally speaking. If your title insurance company says you own this square, it turns out they were wrong, whether it's a legal description or whatever may be the cause that's covered under the title policy, and you lose a tract of land, they will compensate you, or they're required to compensate you for that tract of land, and they'll also defend you in any action that resulted in you losing that land. But here, the plaintiff was not necessarily wrong in asking for compensation, but here was a kicker. As I discussed earlier, title policy covers your title to your property. An easement is not title to your property. An easement is just an access to your property, right? So when the the title company's attorney argued that when the easement was reduced, they didn't lose any title to their property. They didn't lose the size of their property. Their property is still intact. So our coverage was for property, not to keep the size of the easement. Therefore, they're not entitled to any compensation. And then the second issue was whether there should be coverage for the trespass and intentional infliction of emotional distress for the title policy. And I think you guys can figure out why there probably wasn't coverage. Those two counts have nothing to do with plaintiff losing title to their property. When they were sued for trespass, that was due to their own intentional actions of what they did. Now it can argue that, well, look, it was never trespass because they owned that easement, but whether they're trespass or not, that's irrelevant. The question is whether a trespass should be covered under the policy here. The court ruled no, because they acted intentionally when they went out there in their trucks, flicked them off, created all this havoc, put up those cameras, and did all this other stuff that went beyond just an easement that they may have had, right? An intentional infliction of emotional distress. Again, they ruled that, look, if we're not going to defend a case against you for something you did intentionally against these your neighbors, and they sued you for it. This doesn't arise out of the title of the property. This arises out of your own action. And a standard title insurance policy will not cover your intentional actions that results in you getting sued. They'll only cover issues that arise out of your property ownership based upon the legal description and the original title policy coverages that you received. That's a lot that I just threw out there. Again, feel free to ask me questions. I don't think I've seen any questions. I don't see any text popping up, so I'll keep talking. I don't mind that at all. Yep, we'll discuss that. Discuss that you don't own title in the easement. Yeah, there's another. Yeah, so another detail about that is that, you know, the title company didn't insure against the size of the easement. They just said, look, you have an easement. Easement still exists. So when the size is reduced, you're not going to get compensation for it. Detroit Land Bank and tax foreclosure. This one I'm going to go through fairly quickly. It does touch upon title of property based upon tax foreclosures, depending on how you potentially may lose the title and how it works with Detroit Land Bank. Detroit Land Bank has authority that extends beyond, you know, a private property, a private party trying to foreclose on a property, whether it's a bank or even if it's, you know, Wayne County Treasury. Wayne County Treasury has to go through various steps to get the foreclosure done, and then they can give the property to Detroit Land Bank. And after that, Detroit Land Bank expedites the process of filing the quiet title action and gaining, you know, complete title to the property. That's sort of what happened here. Defendant here had not foreclosed, had not paid tax on their property and were eventually foreclosed on by Wayne County Treasurer. Defendant claimed that, look, I was going through hardship. I'm aware of your buyback program. I called you about it, but you guys, for whatever reason, don't want to give me the opportunity to be part of this buyback program. And he also alleged that, look, you guys are doing this because if you don't let me buy it back, you guys can make a higher profit off of selling it in, you know, in open market. And, you know, it makes sense. They will probably make a higher profit if they resell the property. But the one thing that the court stated and clarified, and it's important for us to discuss here, that in general, the Detroit Land Bank actually has a pretty good reputation of trying to keep people on their property. That's why they offered this even buyback program. And, you know, they don't have a record of, you know, being malicious or trying to kick people out of their homes when they really have, you know, a true claim to their homes. They'll do anything and everything in their power to keep people, you know, under one roof, under the roof of their home. Here, the problem was, even though the defendant, you know, was arguing that, look, I was kicked out improperly, and I was not given this opportunity to be part of the buyback program. But the court looked at the statutory, the factual history. The defendant essentially never put a written statement to the plaintiff, the land bank, stating that they are interested in the buyback programs. There's no record of that. Never even attempted to pay any of the taxes. So there's no record of even an attempt to pay the taxes or even partially pay the taxes, and did not come forth with enough proof to show they even had the ability to pay the fees of $1,000 to be a part of the buyback program. So for all these reasons, the court said, look, you've been given adequate opportunity. For whatever reason you claim, that you were unable to take advantage of it. We understand you're going through hardship, but at the end, you haven't paid your taxes. You've been given various opportunities, and you haven't come forward with any evidence. You were even given a chance to go get a lawyer and present the evidence. You didn't do that. So eventually, after I think a few hearings, the court ruled in favor of the Detroit Land Bank, and you have entitled to the property. Okay, this was a fun, sort of a fun one. This has to do with the 18th hole on a golf course that eventually was known as Jack. It was eventually a golf course on which the Jack Nicklaus Signature Championship was played at. It's a senior professional golf. It's a PGA tournament. And I think it's held biannually. So yeah, I think it's held biannually. So I don't know if it's going to be held this year, but I think it's next year is the next one. But anyways, this case deals with the 18th hole on this golf course, and not the first 17 holes were good. There's no issue. There's no problem. The 18th hole, with the 18th hole is where this issue comes up, and you have to go all the way back to 1955. Even though this is a recent case, you really have to jump all the way to 1955 to understand what actually transpired here. The New Products Corporation, they acquired the land in 1955, so they had title for the longest time in Benton Harbor. So they were paying taxes in Benton Harbor for this property for the longest time. However, at the same time, the Benton Township was assessing the property taxes on the same parcels to an individual named Frank Hoffman. I don't know why the F turned into question marks over there. Yeah, I'll fix that. But yeah, it's supposed to be Hoffman. So two people are paying taxes on this parcel in which now the 18th hole exists, right? And Frank Hoffman acquired the property back from the state of Michigan, who for a time period had title to the property because it was foreclosed upon. Frank Hoffman eventually got the title back, and by 2007, they sold it to Harbor Shores Golf Course LLC. And so now to set this up, so new product, they've owned it since 1955. Frank Hoffman had interest since 1973 and sold his interest to Harbor Shores Golf Course. Now the dispute here is between Harbor Shores Golf Course and the New Products Corporation. This shows some more background. This parcel, it borders Paw Paw River, and yeah, I think it was a fairly large parcel originally, but it was split up later on. But eventually, like I said, it was something that was transferred to Harbor Shores. And it fell on this area between these two townships. It was even difficult for them to determine which township it owns the right to taxes. So the property was essentially being double taxed and owned by two different people, which, back in the days happened a lot more than it does now. That being said, this issue didn't get resolved till now. So one important thing that really assist in determining who would have the property here was both both parties at one time started talking to each other, figured out that there was this issue over who actually owned the property. Benton Harbor Shores Golf Course LLC, which obviously you can tell they wanted to be a golf course, told New Products Corporation that, look, they want to build on this and they feel like they own it. New Products Corporation disagreed, said no, we believe we have title to this property, and which resulted in, you know, the eventual dispute. However, one thing that New Products Corporation did wrong was, after they were talking, the discussions just stopped for a while. Both people said they own it, but then they stopped talking. A couple of years later, and I believe this was in 2011, the original discussions were in 2008. Then in 2011, Harbor Shores started construction. They started building a golf course, and New Products was fully aware that they were building a golf course in around 2009. They started construction, and it was completed soon thereafter. And New Products stayed completely silent. So the 18th hole of this golf course was on this disputed piece of parcel. New Products then files a lawsuit that says, we own the 18th hole. They can have all the 17 holes. We have access to the 18th hole, and, you know, they have improperly built on our property. Now, as I'll discuss later, if you look at truly the chain of title and the marketability, New Products actually had a legitimate claim that they likely would have won if they acted immediately in 2009 when Harbor Shores started constructing the golf course. The problem became, there's a principle or a legal doctrine called laches, also unclean hand and estoppel defense, but really laches here. The laches essentially states that if you have a certain right and you're aware of that right, but you don't act upon that right, you may no longer be able to, you may be equitably stopped from later pursuing that right. And the rationale behind that is exactly what happened here. They allowed all this construction and development of the golf course to happen, knowing that it was happening. They have full knowledge of it. The facts are not disputed at all. But for whatever reason, they sat on their rights. Then when it was done, then they filed a lawsuit saying they own their property. So court ruled that based upon the equitable considerations of laches and also the estoppel defense, that New Products can no longer assert this claim, and they have lost the claim to this land, right? Now, earlier I mentioned, this also leads me to another discussion as to who truly would have owned the property if New Products would have brought the suit, let's just say 2009, let's just say they break ground to see this construction happening, there's a golf course, they look, what are you guys doing? We already told you we own this property. They immediately bring a lawsuit. And if that was the case, under the new clarified Michigan, and let me pull it up right here, Marketable Record Title Act, New Products actually would have probably won this case. The court would have probably ruled that they have superior title, and the reason being, the 40 years chain of title goes to is in favor of New Products, as we've seen that they owned the property since 1955. So in 2009, they would have owned the property for more than 40 years. So they would have a clear chain of title for 40 years. Now, Harbor Shores Golf, they brought it in 2007, but the idea is there a clear chain of title going back to 40 years that gives them access to it, right? That gives them title to the property. Here, the clear chain of title only goes back to 1973 when Frank Hoffman acquired the property from the state of Michigan. So when Frank Hoffman acquired it, that 40-year ticker started, right? And then Frank Hoffman then passed that title on to Harbor Shores Golf. There's a clear chain of unbreakable title there. But as of 2009, they were at 39 years. They had not hit, or 38 years. Yeah, 38 years. They had not hit the 40-year marker. So new products actually would have won this if they just brought the lawsuit. I don't think it would have been that heavily contested. Well, I take that back. It always is, especially when seems like Harbor Shores was building this massive, nice golf course. So I'm sure they would have had a lot of money fighting this. But long story short, they sat on their rights, and the court ruled that, look, you can't sit on your rights. You may have been the rightful owner of this, but now you lose the property. It's kind of a harsh decision in a sense, but it would have been just as harsh to allow them to gain the property after Harbor Shores had already built on the property, right? They built this beautiful golf course, and his 18th hole was on it. So it would have been unequitable in that way too. I think the court got this one right. If, again, any questions, feel free to jump in. I'm open to discussion. I'm actually going to take a quick break here, for just a 30-second break or a minute break for you guys to, get your thoughts together, and before I move on to the next section of this presentation, which now no longer deals with cases, but just updates in different laws and recent developments relating to title and real estate. Okay, I still see no questions, so I'm going to proceed. This is kind of a continuation of the last slide with the case with the marketable title, because the updates in the Marketable Title Act actually had a bearing on that ruling. In 2019, the Marketable Title Act was updated, and it clarified something. This was something the Michigan Land Title Association was looking for clarification for a while, because when title companies were pulling searches for whether the title was marketable, whether there was there's a broken chain, or whether there was any interest in the property that need to be addressed or searched and provided to the owner, they would have to just go back as far back as possible, search for anything and everything, because historically what people would do is have a statement in their the deed saying, and here I quote, they would just have a statement in their deed stating that this covers any and all recorded interest in this property, this parcel. And based upon just that statement, a title company would then have to say, look, well, even if something that dates back before 40 years, if it was ever recorded, we have to search for it and try to find it. But the amendment in 2019 clarified that the title company's duty is to only search up to 40 years to determine what exactly exists in the chain of title at that time, 40 years from the date the search occurs. The only time they have to go past the 40 years is if there is a document that the 40-year record shows has specifically, sorry, let me restart on that one. If there's a document that shows a specific library and page number that goes back to 40 years. So for example, you buy a house, your title company does a search, there's a property, there's a master deed perhaps that's referenced in a deed by the previous owner in 1980. Well, it includes a LIBOR and a page number in there. So now the title company has to go look up the LIBOR and page number, even though that deed or the master deed may have been recorded 60 years ago. If it did not include a specific reference to the master deed or any other document, then the title company will not have to go back beyond the 40 years like it used to. So the difference now is the mention must be specific to the page and LIBOR number for any documents, and it must be included in all documents, in any documents within the last 40 years. So specific reference in any document in the last 40 years, then the title company must search that document. But how this also impacts owners, developers, and condominium associations is they actually may want to update and file an affidavit with records that date back past the 40 years. It's quite possible that they have not been incorporated by specific reference in any document in the last 40 years. So if a condominium had a master deed that was recorded 50 years ago, but none of the deeds in the record of a condominium unit specifically reference that master deed, it's arguable that that no longer applies to that. Now, we haven't had that litigation. I'm sure there will be counter arguments to that look, well, the association controls this unit, and the plaintiff is aware of it, but it may not come up in the master. Or if it's not as clear as this is a condo, it may not come up in the title search, and which actually happens. I have clients who bought property not knowing they're buying condominium properties because they're site condos, they're not part of a building sometimes. So then the association will have no control over that. Won't be able to collect any taxes or any association fees, or have any right to tell the owner what to do. This same applies to any subdivisions, any easements and restrictions that may have been at one time recorded, may need to be reasserted as of before the deadline, which has now been extended to March 29, 2024. If no questions, I'm going to move further. Okay, the National Secure Notarization Act. One thing that you guys all may already be familiar with is we have this thing called COVID-19, which is why I'm doing this via Zoom, and which is why it's going smoothly enough, but I'm jumping around a little bit, and sometimes I get distracted because of my computer doing weird things here. So I'm getting used to it too. But because of COVID-19, people had to improvise, just like I am here, and the life goes on, right? So the state of Michigan passed this law that notarization for real estate documents can be done under the COVID-19 protocols remotely. Now, keep in mind, Michigan actually does have a law that actually allows you to do it remotely, regardless of COVID-19. But if you want to take advantage of the Michigan law, not the order, not the COVID-19 order, the Michigan law actually requires that the only way you can do it remotely is you must follow these steps, and you must also use a approved vendor that it's like a video software, like a Zoom, but it must have certain features that are pre-approved by Laura, and that's the only way you can notarize documents if you're taking advantage of those pre-approved softwares. Excuse me. The pandemic orders actually expanded that. So look, you can, as long as a notary can visually view someone's card and is able to verify through technology that they're signing the document, they are who they are, then they are allowed to notarize it. So that part, the orders regarding the notary being able to notarize a document that go beyond the Michigan law, that's now been extended to July of 2021. And based upon that, notaries can continue to sign using any software as long as they can verify, who the person is, and look at their ID and confirm they're signing the document. And they can sign off and notarize the document. once that expires, then you'll have to go back to what the Michigan law is, which only allows you to do that under the approved softwares. All right, this was a little bit difficult because I couldn't see the crowd, I couldn't see the people, and I may have been rambling a little bit more, so it was new to me. But I think that's it. This is the last slide. I think all the information is there. I don't even know if there's a human beings behind there or looking at this. I haven't seen any questions, but thank you if you guys joined me and gave me your time. I appreciate that. Like we mentioned, I will share and circulate this presentation with everyone. And I'll stick around for another minute or two if you guys have any questions. Once, twice, three.
Oh, I see. There is a couple of chats questions for you, but if anyone else has any other questions, please type them in now.
I just realized I could see how many attendees there were. Well, thank you everyone for joining me. I seriously thought there was no one attending. I was just talking to myself, and I kept starting rambling, and I was like, man, it's hard to do this when you don't see people's faces, how they react to you. I mean, that's at least how I do it. So other people actually like this when they don't have to be in a crowd. I actually, for whatever reason, enjoy a crowd. Oh, I see Trevor's here too. Hi, Trevor, how you doing? Thank you for joining me and listen to me ramble. Hopefully you guys didn't fall asleep. You know what I bet? I bet most people just left. it's just odd. I'm just kidding. I know you guys all care. You guys are attentive. You guys are all great, good people. BOMO's always good.
All right, if no other questions, we'll say thank you to Yasser for your time, and we hope to see you on our next Mega Education session. Thank you, everyone.
Thank you.